Welcome, everybody, and thank you for joining us today. Before starting, I think we'll get certain disclaimers out. And just so that everybody knows, this webinar is being recorded, and a copy of the recording will be shared with the attendees after the event. To give a brief background about the event, we received almost 200 plus signups for the webinar. And our audience today comprises of lawyers, bankers, fund managers, and professionals from the digital asset industry. We also have or are expecting some of the reps from Monetary Authority of Singapore who signed up last evening. In terms of just the format of the webinar, each speaker will be speaking for 8 to 10 minutes and with a short and to the point presentations that they have put up. And for the questions, as I mentioned, we'll reserve the questions to the end and take them up during the Q&A session. So to kick it off, I think I'll go to the next slide. So as everyone is aware, 2022 was a very volatile year for the crypto industry and the digital asset industry as a whole. There were exchanges collapsing and a lot of global firms filing for bankruptcy. And I think this has made regulators across jurisdictions to look into the space. And some of them have actually come out with regulations like Dubai and Bahamas with a separate law itself to cover for digital assets, while there are others like US and Singapore, which are trying to cover the digital assets under the existing securities legislations. So today, out of the jurisdictions that you see on the screen, we are going to be covering 4 of them. And we'll be breaking down into the latest global regulatory actions that's happening in UAE, United Kingdom, Singapore, and United States. I think with that intro, I'll just pass it on to Julian, CEO and co-founder, InvestaX and IXSwap, to give an introduction about our company, as well as to talk about our products and services.
Sure.
Thanks, Julian. Over to you. Yeah.
Thank you, Nishta. Maybe we could jump to the next slide, Shafali. And welcome to everybody. Thanks for joining, especially to our special guests who will be sharing all of their knowledge and experience with the attendees today. And there's a huge amount of experience here on the call here. My name is Julian. I'm co-founder, CEO of InvestaX and IXSwap. Let me so what we've been focused on since the beginning of this industry, calling it the digital securities and security token industry, is trying to build key infrastructure that comes legal and compliant, so anyone can issue an asset-backed token, a security token, legally and compliantly using real blockchain technologies. And so that's been the big focus for us, building that key infrastructure, because we believe in a world of tokenized assets and in a world of digital currencies, it makes a whole lot of sense to have a world of digital securities, not necessarily public traded, but in terms of the private market assets, all interacting with each other. And that's what's really exciting for us, because we believe that if you look at the history of the capital markets and the public markets, every significant expansion of capital and growth and explosion of value happened when the new technology married the marketplace. Electronic trading, pretty self-explanatory. ETFs is probably the most interesting and relevant when you start thinking about security tokens, because the first ETF in 1989 was actually considered a failure when it launched, because I think it raised $8 million. And now it's a multi-trillion-dollar asset class because all these people adopted that structure, right? And that was technology. And then now I think the real opportunity for the world of finance and the world of private markets is using blockchain technology to wrap real assets, and then the integration with decentralized finance. Can we get the next slide? So what's really exciting about this, I think, is that, where we are today in the digital security token space is just a blip in the ocean, right? We're just getting started. The point of this graph is to show sort of how far Bitcoin has come, how far altcoins, how far stable coins have come. And also kind of the size of that private markets over there, which is it's probably a lot bigger than 10 trillion, depends sort of exactly how you count it. And so what the whole concept, I think, of using blockchain for securities is to tokenize those private markets and then connect them to all the other digital assets out in the space. Today, we will be covering the digital asset landscape, which includes crypto, stable coins, security tokens, digital securities, also includes NFTs, DAOs, all the other tokens out there. And again, important to note that all of those assets that really truly matter are issued on public protocols, even though there is a world for private protocol issuance. The real value from our perspective is issuing your assets on the public protocol so they can interact with all the other digital assets kind of in the space. Next. So what we have built and what we're here to do and our value proposition to the market is we built and run what we can believe is the leading tokenization SaaS platform out of Asia, out of Singapore, licensed by the MAS. We believe that there's a lot of infrastructure needed for this kind of industry. And what we want to bring to the market is we want to allow any investment firm who wants to tokenize whatever assets they want to do that legally and compliantly in a customized, co-branded way. And sort of overnight, they can get into the tokenization industry. And we have licenses from the MAS for CMS for broker-dealer. We have an RMO exchange license as well, which is one of the very first security token exchanges that's actually really built on blockchain in terms of public blockchain and with full support from the MAS. Next. So what from our perspective, why does everyone need a security token, digital security strategy? I think that, it's pretty obvious digital versus paper. But what's really important, I think now is that if you come up with a strategy, you have a strategy, you will be able to make your business relevant. You'll be able to offer new products, new investment products. And if you think about private banks, wealth managers, et cetera, a lot of them fought Bitcoin for a long time, then they folded, they started selling it, then they started selling the altcoins. The next evolution naturally is security tokens, which are asset-backed tokens. It should be a lot easier for that market to understand because we're not trying to create a competitor to, the US dollar or a new money system. We're just saying, here's this whole entire private markets, 5, 6, 7 times bigger than the public markets, basically sitting over there on paper, not transparent, not liquid, old school. If we tokenize that, we can bring the benefits of publicly traded assets and marry them with the return profile and the size of that private markets. That's an enormous opportunity. There's a lot greater margins in private market assets than there are in public market assets because of the nature of how they work. So we believe it's imperative, and the risk is much higher to not do something today than doing something. That has changed over time, and it's imperative for groups to have a strategy for this, create new revenue streams, become Web3 compatible, and increase your distribution channels. Sorry, next slide. And so we coined the term, Web2 investment company, and we took that from, the tech world. So in the tech world, Web2 is Facebook, and Web3 is some decentralized version of social media. And so when we think about Web2 investment companies, we basically mean every single investment firm in the world that hasn't started or touched blockchain yet. What does that mean? It's every real estate manager, VC manager, private equity group, et cetera, they operate today on paper, traditional finance only. There aren't very little, if any, liquidity solutions. It's all, again, on paper. It's a closed system. There's no connection to any of the value and the innovation that's exploding in the rest of the digital asset and decentralized finance space. So if you are one of those firms, which is, again, pretty much everyone, we want to help those firms become Web3 compatible. We want to issue their investments, their securities, as security tokens, digital issuances, in an open system, connect the TradFi asset, the traditional finance assets, with the innovations and the value being built out in decentralized finance, because you're on the same public protocols, and start to really open up the value, make these companies Web3 compatible. It's a daunting concept to sort of say, all right, 50 million, 100 million, billion-dollar asset manager, fund manager, like, how do I get into tokenization? Everyone in the boardrooms are having these discussions. The options are pretty limited, and I'll get to them in the next, maybe the next slide, Charlie. So there's a lot to sort of contemplate. How do you take your traditional business and tokenize it? Well, one option is to build it all yourselves. That's very, very difficult. You need blockchain expertise. You need capital. You need people in your company to focus on that. It's totally possible, of course. And the likes of BlackRock and Credit Suisse and JP Morgan have been that. But obviously, the super majority of investment firms are not of that top tier scale. So building it themselves is very challenging. And ultimately, you've tokenized assets for yourselves in your own network, which is good, but it's got its limitations. The other kind of option for investment firms to get into tokenization of assets is hiring a token issuance company. There were a few out there. Again, you can have some customization, but you've just stayed within your own realms, your own company. And you still have to spend quite a lot of time and energy and get all those necessary sign-offs from the organization. The third option is to say take an asset and take it to what we call the security token exchange. So security token exchanges exist. I think there's ADDX in Singapore, there's T0 in New York, there's Securitize in America, there's Archax in London now. That's key infrastructure for the industry, but it also is very limiting. You've got to take your asset and your investors, you're going to give them to this exchange, you've got to pay a whole bunch of different fees. And at the moment, because the industry is still nascent, there's no liquidity solutions there. But again, it's good, it's valuable, it's happening around the world. There's now 10 or 20 of these around the world that weren't around a couple of years ago. And then there's us, and what we want to say is give the best of the technology, make it customizable, give investment firms a co-branded section, leveraging our broker-dealer license, our exchange license, and it's fast, it's a low cost, it's overnight, you're in the tokenization, you can tokenize whatever kind of assets you want. And we will connect you with IXSwap, which is the first automated market maker for asset-backed tokens in the world, which allows anyone who owns or issues a security token to start their first liquidity pool. Sorry, next. So these are just the modules that you would have. You need to have KYC, you need to have a payments model. We have integration with HSBC, fiat bank accounts. We have stable coins coming to the platform. You can issue all your security tokens, you can trade them, and there's a custody solution as well. And it's all done under the supervision of the MAS. Sorry, next slide. So this is what kind of the platform looks like. I think I'm sort of coming to the end of the introduction, and I appreciate everyone taking the time. The one thing I did want to say is that I just thought about this yesterday. We did the very first security token event in Singapore in 2017-18. It was on the roof of a boutique hotel down in downtown on the bar. There were about 20 people there. No one had a clue what we were sort of talking about. The ICO boom was melting down, and a lot of those initial coin offerings were failing because the whole industry was falling apart at that time, and some of them started calling themselves security tokens because they thought it'd be more valuable to sell securities instead of utility tokens. Anyway, but it was amazing to see now that we can have almost 200-300 people signing up for this event. With the crypto meltdown last year, there's been a huge push towards regulation from a protection standpoint, and scam and fraud after fraud, and it's just been insane. It's been very draining and upsetting, and also difficult to kind of operate the blockchain industry for the last year or two, specifically with the rain down. But I do think that the interest now is certainly much more sophisticated, and you're now starting to see regulators, especially in Asia. USA, we'll hear from Megan a bit later on, and it's got its own, definitely got its own vibe going on. But for the rest of Asia, Singapore, Hong Kong has turned on the taps recently, Korea, Japan. Asian regulators are pro digital assets. I would say that like really clearly from what you'll see and hear today. And I think Asia is going to be, definitely at the forefront of what happens now for the industry across all the different digital assets, whether it's NFT, security tokens, or crypto. And we're super excited to be here building out. So that's enough time for me. I'd like you guys to hear from the rest of the experts on the panel. Thank you very much.
Thanks, Julian. I think just want to reiterate that At InvestaX, we are the first in Singapore and APAC to be providing a tokenization SaaS platform. So with the tech and the licenses, we definitely have the ability to help you out launch your own tokenized platform. So do check us out. Next up from our presenters is Megan Spillane. Megan is joining us today from New York, and she's a partner with Goodwin and Proctor US practice. Megan focuses on litigation and dispute resolution and has also represented big technology companies before SEC. Today, Megan is going to take us down the memory lane and talk about all the enforcement actions that were initiated by SEC in 2022. Megan, I'll let you take it from here. Thank you.
Thank you, and very nice to see everyone. Julianne, I think you phrased it well, and the USA has its own vibe going on. So my task is a heavy one today. I have to explain to you all what's happened in the United States in the past year in 10 minutes. But I also would hope to leave you with something hopeful rather than a lot of doomsday, which is, a lot of what is frankly going on in the United States right now. I kept my slides very light. I'm going to hit on each of these bullets with just a couple of updates about the kinds of things that have been shaping the regulatory landscape in the United States. Fortunately, Goodwin Procter has also put out some thought leadership that gives a little bit more detail about each of these. So I think we can put that in the chat perhaps when I'm done, and you can, to the extent you want to know more about any of these events, that will serve as a really great reference and kind of an omnibus reference about the past year. Anyway, we started the year in February 2022. The SEC brought charges against BlockFi lending. We knew over the course of the past year that the SEC has been focused on interest-bearing products, but the one that really came to the forefront was BlockFi. They had BlockFi interest accounts, which was a lending product that the SEC found to be an unregistered security. BlockFi settled with the SEC. They had to pay $50 million in fines. They also paid $50 million to various state regulators. But significantly, they were going to try to bring their business under compliance under the Investment Company Act. And they had announced their intention to, register under the Securities Act and to go forward and have a successful business. So we all waited with bated breath to see how that would actually work and to see whether there was a path forward in the context of actually settling with the SEC that would result in, a path or a model that others in the industry could follow. Unfortunately, as I'm sure you have heard from following the news, BlockFi entered into Chapter 11 voluntary bankruptcy by November of 2022. And by that point had not, in fact, registered despite its intentions. So kind of the lasting impact of BlockFi is really querying whether this idea of going into the SEC and settling with them can actually lead to the kind of path forward and lead to a business having a path forward in the way that, of course, all of our clients and all the companies we work with would really hope in engaging affirmatively with the SEC. As I'm sure you all know, and this is not specific to the US, but it has impacted, I think, everything around the world, shot heard around the world, is in May of 2022 when the algorithmic stablecoin Terra UST lost its $1 peg, and also the value of its companion token Luna took a hit as well. Basically, there was a series of events that caused the algorithmic peg to break from the US dollar. There resulted in more Luna being minted. They tried to save it by flooding the market and by taking some additional loans and investments. But ultimately, investors lost confidence in Terra and in its companion token Luna, which resulted in really the equivalent of a bank run. And both of the pairs were delisted from exchanges. And in a very, very short period of time, there was about $200 billion in value lost from the crypto space. And really, this was one of the first moments that really, I think, shaped the rest of the aftermath that we've seen in the United States and all over the world in 2022. Flipping a bit to number 3, We also saw insider trading emerge as a trend in the United States, both in the NFT space and also in the digital asset space. This was a very interesting action. OpenSea, as I'm sure many of you are aware of, is one of the leading NFT trading platforms. And basically, because it's so popular, if an NFT is featured on kind of the homepage or the main page of OpenSea, as you might imagine, it gets a lot of notoriety. Everyone sees it, and the value of those assets, the value of those artists, goes through the roof, just based on the exposure. So in this action, US v. Chastain from June of 2022, basically they found that one of the developers at OpenSea had some advance notice of which assets would be featured on the homepage, and decided to buy up those assets in advance of them being featured, with an understanding that, of course, once they were featured on the homepage, the prices would skyrocket. And he was able to sell these assets that he had accumulated allegedly for substantial profits. So the reason this was significant in the United States is that the DOJ went after this individual for wire fraud and money laundering, and basically didn't say that NFTs were securities, purely just said that this was a violation. He had confidential information and he basically traded on it. And it signaled, that the DOJ was becoming active in the space, that NFTs would not be exempt, and also that the wire fraud and mail fraud statutes would be used in the United States to go after this kind of misconduct. Then the next major event that has shaped the regulatory landscape in the United States, and again, throughout, I would say internationally, is, of course, as you well know, in Singapore, a Singapore-based hedge fund, 3 Arrows Capital, which has become known as 3AC throughout the industry, as everything has become an abbreviation. It was a fund focused on digital asset investment strategies. It basically borrowed a lot of money from institutional lenders and used those funds to make large investments. Significantly, it had a large position in Terra Luna, and would make money from the arbitrage positions it took. So when the crypto market started crashing, the lenders, of course, wanted their money back, and 3AC, tried to borrow to make its capital calls and make good on these commitments. But as far as the press is concerned, and some of the allegations that have come out, it was just incredibly over leveraged, and it ultimately defaulted on a lot of its debts. And basically, the collapse of 3 Arrows Capital has had basically a catastrophic impact across many of the major players in the United States in the crypto markets. Voyager and others have cited 3AC as really a reason that they have similarly faced hardship this year too. I'm really realizing that, like, starting off this presentation with all this doomsday, I guess it will bode in favor of some of the other practitioners who speak to you about all the opportunities elsewhere, and hopefully the United States can seize on those opportunities instead of focusing so much on enforcement. On the fourth bullet, the second thing I have listed there is another SEC action, SEC v. Wahi. Coinbase, as I'm sure everyone is familiar with, is a major digital asset trading platform in the United States. It's a publicly traded company. It is, considered by many to be kind of the gold standard of trading platforms in the United States. And this was kind of similar, quite honestly, to the allegations we spoke about a few minutes ago regarding OpenSea. But here, of course, it's digital assets, not NFTs. The allegations are basically that someone within Coinbase who was on their product team would know what new digital assets were going to come up to be listed before they were listed. And in this context, of course, being listed on Coinbase in the United States provides a tremendous amount of liquidity for a given asset, increases its profile substantially, and really creates a situation where there will be a jump in the price of that asset as well, just by virtue of being listed on Coinbase. So of course, these product team members that would know, in advance of a public announcement what was going to be listed, could similarly buy up that asset and wait for it to be listed on Coinbase, wait for the price to pop, and then sell at a substantial profit. So the U.S. Attorney's Office, which is the criminal authority in the United States, the Department of Justice, as well as the SEC, both went after this misconduct. What was significant from our perspective was that the SEC actually identified some of the tokens that the individual had traded in and named them as crypto asset securities. So I think this is different in spirit than when Julian was talking about before about, securities tokens. These are, digital assets that were not registered as securities, that are being traded in the ordinary course, that the SEC has now ex post facto dubbed as being crypto asset securities. It's quite frustrating for the industry because based on what we know, it doesn't appear that any of these 9 issuers had the opportunity to actually make their case or, kind of explain why they shouldn't qualify as securities under United States law. They were just named in this complaint. And it's an example, I think, of the SEC, instead of giving us clear guidance, and this is, me being a little bit of an advocate, but instead of giving us any clear guidance, they're really promulgating by these enforcement actions and trying to, hammer everyone over the head with these enforcement actions, when all anyone really wants is to find a clear path to compliance. And that's really what the industry in the United States demands. And unfortunately, that's just not what we've received, at least in 2022. I realized that, well, I'm going on a pretty good clip here. CFTC v. Uki DAO was something else within the United States and internationally that became a big deal. This became a big deal because a decentralized autonomous organization was found to be basically the equivalent of an unincorporated association. And the Commodities Futures Trading Commission within the United States took the position that everyone in the DAO that had ever voted on any decision within that organization could be jointly and severally liable for the decisions that have been made. This is playing out in real time as a litigation in the United States, but obviously something that we're all watching incredibly closely, because having this kind of impact on DAOs could have, kind of tremendous implications for other actions. The other thing that was interesting about this action is that the CFTC convinced the court that it was appropriate to serve the entire DAO just by posting this complaint on some of their message boards and chat boards, which is of course very different than how any lawyer would think about traditional service, which would involve, actually handing a document to someone or to their agent. The SEC v. Library matter, which is little 6 on my chart here, basically an enforcement action was brought against a particular token, the library token, and a court actually held that it was in fact a crypto asset security, following a motion for summary judgment. So this is still being litigated in terms of what the damages will be, what the penalties will be. But unfortunately, I think it has emboldened the SEC to seek more of these actions and to seek enforcement actions for these technical violations of the securities laws based on their success on the ground with some of these matters. The next thing here, I won't belabor too much. I'm sure everyone is aware of everything that's going on with FTX and its founder, Sam Bankman-Fried. But obviously, it is putting kind of a mark or a stain on a lot of the positive things that have been happening in the industry. And I think the allegations against Sam Bankman-Fried and his cohorts at FTX and at their market maker Alameda can only be properly categorized as fraud. It happens to be fraud in the digital asset space, but it could be fraud in any other industry, and it's unfortunate the focus that has received and kind of the blemish that has resulted from that. And then we're moving on to this slide. Yeah, I guess skipping. Oh, Nisha, it's okay. We can go to the next slide. There were a few other things here, but it's basically largely duplicative. And I think the punchlines is really what's important here. So out of all of these actions, and as we look into 2023, There's a lot that we can be learned from everything that's happened in the United States over the past year. As indicated by all of the things I just went through, there is a renewed vigor and a really heavy hand of enforcement in the United States right now. It is not a time that favors innovators. We don't have the impression that our regulators are digital asset friendly right now. If anything, it seems that they're all competing with each other for who can get the biggest piece of this regulatory pie in a way that's quite unfortunate. As we saw from the BlockFi settlement, settlements are showing challenges to a clear path forward. There's scrutiny on interest-bearing products. The US regulators are looking at the intersectionality between different companies that tend to work together or collaborate and seek to hold liability on both sides. I think in light of FTX and other centralized finance platforms, there's a real good argument for DeFi as avoiding some of these problems that seem to be inherent in having too much of a concentration of control. There's also on the horizon in the United States challenges facing stable coins, not only the algorithmic ones like Terra, but also some of the ones that are more straightforward. The BUSD in particular is being challenged by the SEC in the United States right now. With all the bankruptcies that we're facing, there are issues about who owns those digital assets that are on the platform when it goes into bankruptcy, which has a lot of real life implications on customers. And then, finally, in light of all this enforcement activity, there really is a call to have some congressional action. And there's this Digital Commodities Consumer Protection Act of 2022 that's still kind of percolating around. Unfortunately, I think SBF was one of its biggest proponents, which has put it under scrutiny in light of everything that's happening with him. But I think, with all of this said, I remain quite hopeful about what's to come in 2023, because I think the pendulum is going to have to swing backwards towards some practical solutions to these problems. And hopefully, some, kind of power and camaraderie within the industry to come up with these solutions. And I personally am very excited to be part of that. So thank you very much for your time. And I will put the article in the chat in case you want to know more about any of the things that I discussed about regulation in the United States. Thank you very much.
Thanks, Megan. That was really insightful. And yes, definitely there are questions in DAOs, stablecoins, and whether stablecoins are securities and not. And all the enforcement actions from SEC have led, other global regulators like UAE and UK to think about regulations. And that brings us up to our next speaker, which is Hagen Rook. Hagen is a partner with Reed Smith and a director with Resource Law LLC. I think he needs no introduction. Hagen, if you are a Singapore entity dealing in digital assets and Web3, you would definitely have heard about Hagen Rook. He is very, very active in the fintech space here in Singapore. So I'll let you take it from here, Hagen, on the UAE and the UK framework, which is much talked about now. Over to you, Hagen. Yeah.
Yeah, thanks very much, Nishta. That's a very kind introduction, and that was an excellent overview of the landscape in the US from Megan. Slightly dark and dystopian, ending with a message of hope. And I suppose I now get to bask in the warm light of some of the more positive developments that we're seeing in the UAE and the UK, and to some extent also the EU. So next slide, please. Yeah, so when we discuss developments in Singapore, we often in tandem look at what's going on in other jurisdictions. And one that comes up quite a lot is the UAE, which is attracting a lot of interest at the moment from various clients. And there's hardly a day that goes by when we don't talk about the possible structures that can be implemented in the UAE. And so we have a very particular framework in the form of the Dubai Virtual Asset Regulatory Authority, VARA regulations, just adopted a few weeks ago in the form of 13 rule books. And so VARA is a new regulatory authority that sits alongside two others, the other one being the ADGM, or Abu Dhabi General Market, and then you've also got the DIFC, or the Dubai International Financial Center. And those frameworks also have crypto regulations, but they are not focused only on crypto in the way that VARA is. So VARA is a very, very dedicated framework. VARA applies throughout the Emirate of Dubai, except in the DIFC. So if you're in the DIFC, you need to register as a virtual asset service provider with the DFSA. VARA is in the remainder of Dubai. If you're in Abu Dhabi, it's the ADGM. And if you're in other parts of the UAE, then you are basically what we call onshore, and you're within the jurisdiction of the Securities and Commodities Authority and the UAE Central Bank. Those authorities are still in the process of developing their own virtual asset regulatory frameworks. So it's a very piecemeal landscape overall, and those different free zones and regulators are all competing with each other for business. And so whenever we talk about the setup options in that part of the world, we kind of have to go into a little bit of a comparatory sort of compare and contrast to outline sort of what the different options are. But VARA seems to be a very popular one as things stand. Next slide. So I mentioned there are a number of rule books. 5 of these are legally binding, and the remainder are basically guidance. So take the form of guidelines, very similar to the way that other regulatory frameworks in jurisdictions like, for example, Singapore, are structured. And what's interesting about the VARA framework is that it covers lots of different types of regulated activity, many more than we're seeing in other jurisdictions. So the activities include, for example, advisory services, broker-dealer services, custody, exchange services, lending and borrowing. That's quite a novel type of activity to be regulated in the crypto space. Payment and remittance services, and management and investment services, specifically in relation to crypto. And interestingly, even if you're not operating within that core area that service providers in the crypto space operate in, so for example, if you're just a SaaS provider or a technology service provider, you can still optionally get a license with VARA. So that's going to be quite interesting, I think, for lots of players. Next slide, please. So the thing about the VARA framework is that it comes at a time when a lot of other crypto frameworks have already been developed and published. And so VARA is in a way drawing some of the, from some of the lessons learned in other jurisdictions. And it's really quite a refined framework. So just on I think we've skipped ahead, but the previous slide just gave an example of that by sort of outlining how token issuance is defined under the VARA framework. So token issuance is something that's typically quite ambiguous in the way that it's regulated. If you take a place like Singapore, for example, we have the concept of dealing in digital payment tokens, but it's a little bit of ambiguity around how systematic that dealing needs to be in order to be regulated, whether a one-off token issuance can be conducted out of Singapore on an unregulated basis. VARA provides much more comprehensive guidance on that type of issue. The other thing, also on the previous slide, is that if you're operating some form of Web3 type structure with decentralized elements, but you have touch points in Dubai, then you can still obtain a license from VARA. VARA will want to know exactly how you're using the decentralized elements of your structure, and how you are nonetheless eligible to be regulated and you can be effectively supervised. So very forward thinking, taking account of the various kind of decentralized and offshore structures also, that or combined onshore and offshore structures that we're seeing in the crypto space. So this framework will no doubt continue to attract a lot of attention, and will be increasingly a very viable alternative to other frameworks such as Singapore and Hong Kong. So with that, we'll move on to a quick whistle-stop tour of the UK framework. Next slide. So in the UK, I guess the industry is at a slightly different juncture, and we have for a long time had a very mature, very sophisticated and comprehensive TradFi framework under the the Financial Services and Markets Act 2000, known as FSMA. And FSMA for a long time now has regulated activities in relation to conventional products such as securities and derivatives. What the government has done recently via a consultation is to propose that this existing framework be expanded to also cover crypto assets. So we're seeing a proposal really to regulate crypto assets in the same way that conventional assets are already being regulated, or activities in relation to those assets are being regulated. But of course, in a proportionate manner, so there are some adaptations and some adjustments that the government is looking to make in relation to crypto. We also, in parallel with that general expansion, have seen a few specific initiatives. So, for example, there is a new proposed framework for fiat-backed stablecoins that are used for payments. And we've also seen new regulations relating to financial promotions or marketing of crypto assets. Next slide. So I'm not going to go into this in a huge amount of detail, but a crypto asset is defined very, very broadly under the proposed UK regulations. And it'll essentially capture everything under the sun, including NFTs and stablecoins and security tokens. But what the more detailed regulations that will follow in due course will do is to narrow down the application of relevant requirements for relevant types of crypto asset. So what we have at the moment is a very broad legislative framework that's going to be fleshed out in greater detail by the Financial Conduct Authority, the regulator in the UK. And we're going to probably see several further phases of consultation on those more detailed rules. And we'll see then how progressively different types of activity will be brought into the scope of regulation. Next slide. So one thing that has attracted a lot of commentary is the territorial scope. It looks like the crypto asset activities that will be regulated are those that are either provided in the UK or to UK customers. It's likely that if you're looking for a license in the UK, you will need a local presence. One question that's kind of open is whether if you're providing cross-border services in the UK, you'll be able to benefit from a so-called overseas persons exclusion. That's still under discussion. Next slide. So these are the actual activities that are due to become regulated over the course of time. At the moment, we only have the legislative framework that provides for this, but it looks like only some of these activities are going to be regulated in first instance. These include crypto asset issuances, certain payment activities, and certain safeguarding and administration services, i.e. custody. But as you can see, there are various other types of activity that can be regulated and probably will be over time. Interestingly, there's a new market abuse framework that will also sit within this expanded regulatory regime, and that will capture things like insider trading and market manipulation relating to crypto. So that's a quick whistle-stop tour of the UK regime. Very interesting developments there. Next slide, please. And the UK is, clearly looking to position itself as a crypto-friendly hub. I think that's probably partly a function of the post-Brexit circumstances in the UK, where the UK has an opportunity really to also diverge from the EU and streamline its regulatory approach a little bit. So next slide. So I'm going to touch very briefly on the EU DLT pilot regime. I won't spend too much time on this because I'm conscious of time generally. But what this regime does is it's really a sandbox. So it allows operators of market infrastructure to trial their platforms. And the reason for this is that typically if you have a distributed ledger technology or blockchain-based platform that provides, for example, settlement services or trading services, in the EU, you would be subject to relatively onerous requirements in relation to central securities depositories, which need to record the transactions. You need to usually meet the very onerous requirements for, say, a multilateral trading facility, or a combination of both of those things. And that can be actually quite a stifling factor when you're looking to trial a new type of technology. So cognizant of that, the EU has introduced this pilot regime, which I believe takes effect on the 23rd of March. Next slide, please. So what you can do if you are eligible is you can apply to a national regulator in the EU, and the national regulator will potentially allow you to operate in this regime framework for up to 6 years, which is quite a long time. It's a little bit unclear what happens after that period. We'll have to see. But whilst you're in the sandbox, you'll be able to enjoy dispensations from relevant EU law requirements, capital requirements, conduct requirements. Exceptionally, you may be able to provide your services to retail customers, or you may be exempt from trade reporting also. This is just one final point to note that, of course, there will be limitations. So we note the limitations there in the bottom half of this slide. As a participant in the pilot regime, you at the outset can't have more than 6 billion euros worth of financial instruments submitted to trading on your platform. And then over the course of your lifetime as a platform, that figure can't exceed 9 billion. National regulators may choose to set lower limits, however. So that was just a very quick overview of that development, hopefully a positive one and one that will be used and will further progress the use of blockchain-based technology in conventional capital markets. With that, I'll hand back to Nishta.
Thanks, Hagen. That was a quick overview of the VARA and the UK regulations. And I think VARA is one of the most comprehensive legislations that has come out with, the 13 rule books. There are many other jurisdictions that are trying to put things in context, and the 5 of them which are compulsorily applicable cover very important aspects of a digital asset. With that, I think we'll move to our next presenter, Joy Lam. Joy is a partner at Baker McKenzie, and she's an absolute supporter of the virtual asset ecosystem in Hong Kong and outside. Joy has also worked with multiple clients on tokenization of funds and assets. Today, Joy is going to talk about the consultation paper that Hong Kong released very recently and the much talked about retail access to digital assets in Hong Kong. So with that, Joy, I would like to hand it over to you.
Thanks very much, Nishta. So look, there's been a lot happening in terms of changes in Hong Kong's regulatory landscape. A bit of background. The SFC, the regulator here, was certainly an early adopter of the approach of regulating crypto asset service providers, not just from an AML perspective, but also from an investor protection and a market integrity perspective. Way back in 2019, they were very early to release a statement on security token offerings. And they basically said, all security tokens are complex financial products. And that means that under the existing regulatory framework, they can only be offered to professional investors. So basically, retail investors had no way to access security tokens. The SFC has been, I think, comprehensively regulating various digital asset related activities since 2018, including services provided by entities that are already licensed, relating to fund managers that are investing in virtual assets or distributors who are distributing virtual assets. So for both of these activities, licensed entities would actually need to go to the regulator and get a separate consent in certain circumstances to kind of expand that service offering into digital assets. We have seen the regulator grant quite a few of these virtual asset fund management licenses in the last couple of years, but consent for virtual asset distribution activities for licensed entities has certainly progressed much more slowly. And they have also been regulating virtual asset exchanges, provided that the exchanges offer at least one security token for trading. And the reason for that is that the SFC's jurisdiction really is limited to securities and futures. So exchange operators that wanted to be licensed would need to actually offer at least one security token in order to come within the SFC's jurisdiction. But this is actually now changing because the government's introduced amendments to the anti-money laundering ordinance, which are going to take effect in June this year. And that's basically expanding the SFC's jurisdiction and giving them the ability and the authority to regulate all virtual asset exchanges, regardless of whether the tokens are securities or non-securities. So in the last couple of years, what we've seen in Hong Kong, I think, is a real lack of distribution channels, a lack of secondary market trading venues due to these regulatory requirements. And this really has constrained the security token market quite a bit here. So, we haven't seen a lot of deal flow here. And where we have seen deals, frankly, the issuer or the asset may be based here, but they go elsewhere. They look at exchanges in Singapore or Europe, the US, other locations for liquidity and for capital raising. So in FinTech Week last year, which was late October, early November, there were quite a few changes that we heard, and really they are game changers for the digital asset ecosystem in Hong Kong. So the first thing we had was the government released this policy statement on the development of virtual assets in Hong Kong. And there were a couple of key points, I guess, to note from that policy. One is the government recognized that virtual assets are here to stay. They were very clear in saying that the government and the regulators are working towards creating a facilitating environment that will promote the sustainable and responsible development of virtual assets in Hong Kong. They're going to try to adopt, in principle, same activity, same risks, same regulation, because they want to allow innovation to thrive in a sustainable manner, but they also want to have appropriate guardrails to manage potential risks to financial stability, consumer protection, AML, and these sorts of things. Much talked about, they opened the door for retail investor participation through crypto futures ETFs. So we had a couple of those launch late last year, as well as access or giving investors, retail investors, access to a limited range of digital assets that will trade on licensed exchanges. And this really is seen as a very significant change in the government's approach. Because initially they were very clearly and very staunchly saying crypto digital assets not appropriate for retail, and we're going to limit it to professional investors only. And then to kind of, I guess, solidify and demonstrate their commitment to virtual assets, the government also announced a couple of pilot programs, including the government itself issuing tokenized green bonds. So they really are kind of trying to commit and demonstrate that there is very significant policy support to grow Hong Kong into a hub for these kinds of activities. So on that same day, we also heard from Julia Leung, who is now the CEO of the SFC. She also spoke about virtual assets. She tackled the elephant in the room of the PI-only restrictions head on, and she basically said, having seen the way that the digital asset market has developed and matured and grown since their initial 2018 statements, that the regulator is now comfortable with allowing retail investors to access digital assets, subject, of course, to appropriate safeguards. They really acknowledged the benefits of distributed ledger technology, and again noted that the landscape has changed quite a bit since 2019 when they issued that initial circular on security token offerings. And so the key change coming from that really is that tokenized securities, which are digital representations of traditional securities, should be treated in the same way as existing financial instruments are. So security tokens are no longer going to be complex financial products just because they're issued or traded on the blockchain. Instead, vanilla, for example, vanilla bonds, which happen to be tokenized, they're still going to be considered non-complex products in the same way that non-tokenized vanilla bonds would be, which means that they can actually be distributed to investors that are not professional investors, subject to suitability requirements. Of course, if a security token does have particular features that are more complicated or more novel, then they may still fall into the category of complex financial product, in which case, again, they'll be limited to PI. So it's really what are the actual features and the rights that are attached to the security token? That's what you have to look at to determine whether or not it's a complex product or a non-complex product. And from there, you can then figure out, is it something that retail investors can access, or is it something that is limited just to professional investors? They also mentioned that they do expect licensed entities that are distributing tokens to conduct reasonable due diligence and actually conduct smart contract audits before tokens are distributed to clients. And they specifically mentioned that there will be more guidance coming on STOs, although they haven't indicated when that guidance is going to be issued. So all in all, based on what we heard at FinTech Week, the takeaway is virtual assets are not going anywhere. The government is supporting it, subject, of course, to appropriate safeguards. And we can expect more consistency and predictability and also clarity in how virtual asset related products and services are regulated going forward. Next slide, please. So as Nishta mentioned, the topic that everyone is focused on right now really is the SFC's public consultation on the proposed regulatory requirements for virtual asset trading platform operators. So I mentioned before, there's this new change that's coming in under the anti-money laundering ordinance, which is giving the SFC authority to regulate virtual asset exchanges, regardless of whether the tokens are securities or non-securities. And what they've done in this public consultation is set out some proposed guidelines for all virtual asset trading platform operators. So they're really aligning the requirements that will apply for virtual asset exchanges, whether it's trading security tokens or non-security tokens. So there's no longer any regulatory arbitrage as there was previously. It's now going to be a level playing field for all virtual asset exchange operators in Hong Kong. So the key changes I think that most people are talking about, really, streamlined listing process, which is pretty key. So under the current regime, you need to get SFC approval for each and every token that is listed on the exchange. And this requirement is largely being jettisoned under the proposed new guidelines. What they're proposing is that for tokens that are offered only to professional investors, you don't need to get SFC approval. The token has to pass the platform operator's due diligence requirements, and then the operator notifies the SFC that the token is going to be listed. The requirement for SFC approval of particular tokens is going to be retained only for tokens that are going to be offered to retail. They've also set out a very clear pathway for retail access to virtual assets. So retail investors are going to be able to trade eligible large cap virtual assets. And there are some conditions around, what is going to qualify as a large cap virtual asset, but it will have to be included in at least 2 indices, and it can't be a security because that creates. There are other, regulatory requirements that will apply for securities that are offered to retail investors. So, under this current proposal, even though I guess the access for retail investors is a fairly limited range of large cap virtual assets, the market generally does see this proposal as a very fundamental shift in regulatory approach, and it is seen as a signal that the increasing adoption and integration of virtual assets into the financial system will continue to be allowed and supported by the regulator and the government. The consultation also sets out some pretty detailed requirements for the exchange operators, in terms of how those exchanges actually operate, and it covers, you know, a whole range of different areas, including some of those that are noted on the slide there. But you know, I think the key point really in terms of security tokens is that previously there were additional requirements that applied to security tokens, and those are now being scrapped. So it's actually going to be much easier now for licensed exchanges to list security tokens on the exchanges for trading. Next slide, please. So this is just a very high-level summary, I guess, of the key parts of Hong Kong's regulatory framework as it relates to security tokens, but I won't kind of go through this because I know we're running short on time. But you know, really the key takeaway, I think, for us in Hong Kong is the changes that we've seen from the regulator, the approvals that we've seen them grant, as well as these proposed regulatory changes that people are talking about. They are a game changer for virtual asset investors and businesses in Hong Kong because they're expanding access. So we're seeing new channels of access through properly regulated institutions, and that's critical to ensuring that the regulatory regime protects the broadest range of investors, while also giving those operators who are willing to meet the regulator's very rigorous requirements more business opportunities. And I think these two, you know, elements, they're really interdependent, and they're mission critical for Hong Kong in particular, which has this aspiration of developing itself into a virtual asset hub. So, you know, lots happening, lots to come still, but definitely all kind of moving in the right direction, and you know, moving towards opening up and broader adoption. Back to you, Nishta.
Thanks, Joy. Good to see SFC in action, and you know, we still need to see how the retail access plays out, and of course, there's some inspiration there for other jurisdictions to provide retail access. I'm mindful of the time. We might run a bit. We are running a bit over time here, but we'll take up our next speaker, Adrian, and then we'll also be doing some question answers towards the end. If there are people who are willing to stay back, please do so, but we'll be sharing the recording as I mentioned earlier. So, yep, next up is Adrian with us. He's partner with Allen and Gledhill. Adrian, I think, again, very active in the fintech space. He also co-heads the ESG, fintech, and public policy departments at Allen and Gledhill, has advised on a lot of fintech-related legislations, works very closely with MAS. So over to you, Adrian, to talk about the Singapore framework.
Thanks, Nishta.
Thank you.
Next slide, please. Yep. So I'll try to keep it very brief. I think in Singapore, the important thing to note is when we talk about digital assets, the broad split is between security tokens and digital payment tokens. Security tokens are basically tokenized versions of traditional capital market products. So when you hold one of these security tokens, basically you get the rights that are similar to the rights that you would get for a traditional capital market product. It's just that it's in tokenized form. The other category would be digital payment tokens, and broadly speaking, you can call these cryptocurrencies. So things like Bitcoin, Ether, Ripple, Litecoin, USDT, USDC, essentially single currency stable coins. All of this would be categorized under digital payment tokens in Singapore. And why is that important? The split is important because basically different kinds of regulations apply depending on the categorization of these digital assets. So for example, when we talk about security tokens, basically it comes under our Securities and Futures Act. In terms of regulation, it is not that different from traditional capital market products, except that with security tokens, perhaps there's a greater focus on technology risks and addressing them. In contrast, if you talk about cryptocurrencies or digital payment tokens, that comes under our Payment Services Act in general. And there is a different licensing and regulatory regime. Now, in terms of changes that have happened, as well as changes that will happen in the near future, the focus is really on these cryptocurrencies. It's not so much on security tokens, although I think there is a push towards making it more efficient for service providers to deal with security tokens. And I'll talk about that at the end. So let's focus now on cryptocurrencies or digital payment tokens. So what was the outlook in the past, right? How did regulators see cryptocurrencies in the past? Well, I think most of us know that at best, many regulators were neutral about cryptocurrencies. Certainly some regulators like those in China and India and to a certain extent Korea during the early days were not in favor of cryptocurrencies. Many of the regulations back then addressed AML-CFT concerns, and essentially that was it. Certainly that was the case for Singapore. The current, right at the start, the first version of the Payment Services Act focused on AML-CFT risks. And what was also consistent and continues to be consistent today is the focus on the underlying technology that underpins a lot of these cryptocurrencies, essentially the blockchain technology. Now, how has that changed and how will it change? Well, we've subdivided this into 4 categories: plugging loopholes, expanding the scope of existing regulated activities. Number 3, regulating new cryptocurrency activities. And number 4, a greater focus on security tokens. So next slide, please. Next slide, plugging loopholes. Very quickly, Singapore passed in Parliament the Financial Markets and Services Act. And basically what this does is, Basically what this does is it deals with companies that have incorporated in Singapore but have all their activities done outside of Singapore. And this, the point of this is the regulators don't want a situation where let's say you incorporate a company in Singapore, but all your activities are undertaken in country X. So your employees all live in country X, your hardware, software, that's all in country X. The regulators don't want a situation where the regulators in country X go up to you and ask you whether you need a license or you need a regulation, and basically you say, well, we're incorporated in Singapore, so we really fall under Singapore's jurisdiction. And on the other hand, when the regulators in Singapore come to this bunch of people and ask them the same question, the people then say, well, even though we're incorporated in Singapore, our business and activities are in country X, so we come under the jurisdiction of country X. And if you have this kind of scenario, potentially, this business basically falls through the cracks, and potentially it doesn't get regulated in either Singapore or country X. So the FSMA is to address situations like this, bearing in mind I suppose the global nature of many fintech products and services. So if you are incorporated in Singapore, and notwithstanding that your business may be in country X, you would need a license under the FSMA. Now, currently, this license essentially deals with AML-CFT requirements. So if you need a license under the FSMA, you'll be regulated for AML-CFT issues. Next slide, please. Expanding the scope of regulated, existing regulated activities. So, with all the negative press about involving cryptocurrencies in the news, there is no surprise that there has been a movement towards further regulation of cryptocurrency businesses. And this is basically a move to expand these regulations from simply looking at AML-CFT issues to to more areas, including consumer protection concerns. Next slide, please. So I think one thing to note here is that these, what I've listed in the next few slides, these are actually in consultation form, right? So they are not actually passed into law yet. In fact, they have just been consulted on. The consultation came out in December. The regulator has not issued the response to feedback for consultation. So these are broad ideas that are being proposed, but they are certainly not set in stone. So what are some of these proposals? Well, as I said, there are consumer access measures. So things like making retail investors take customer knowledge tests to see whether they have enough knowledge to understand the cryptocurrency services or products that they may be purchasing. That's one of it. Putting greater structure towards determining who can be an accredited investor. So again, right now our accredited investor system is a monetary threshold, but how do you count cryptocurrency in this equation? And do you limit the amount of cryptocurrency that can be counted towards the monetary threshold? So that's being proposed as well. Sorry, can you go back, please? Yes, next slide. The regulator in Singapore is also proposing on business conduct measures. So things like protecting against the bankruptcy or insolvency of the cryptocurrency service provider. There are proposals as to making sure that customer assets are segregated, that they may be put with a licensed custodian, where that licensed custodian will be situated, whether it's a licensed bank in Singapore or otherwise, and so on and so forth. Next slide, please. Of course, one of the outstanding risks would be in relation to technology. And again, we've read in the news about how many of these cryptocurrency service providers have been hacked and basically customer assets lost. So that there is also a push to establish a high level of availability and recoverability for critical IT systems, and to put into regulations the need to report these incidents to the regulators. So basically to increase the level of policies and procedures to address technology and cybersecurity risks. Next slide, please. Market integrity. I think some of my colleagues right at the start talked about market manipulation and insider trading as it applies in the US. I think right now, if we talk about cryptocurrencies in Singapore, our market manipulation and insider trading laws don't actually apply, because these apply to capital market products. And as I said right at the start, cryptocurrencies are not capital market products and they are not security tokens. So there is that exposure where somebody can basically run a pump and dump scheme, for example. So there are proposals from the MAS to basically address market integrity concerns as well. Next slide, please. Stablecoins. This is the second consultation paper that MAS issued in December. And basically it talks about, so right now, single currency stablecoins are considered digital payment tokens, and they are regulated as such. If you issue a single currency stablecoin, you basically need a license under the Payment Services Act for providing digital payment token services. There is a proposal now to create an enhanced tier of stablecoins. So if you meet certain additional proposed conditions, you would basically be able to call your stablecoin something else, which is a little bit more special and I suppose a little bit safer. So the proposals revolve around what these additional conditions should be, and they revolve around keeping reserves, making sure that the redemption to fiat currency is within a certain prescribed period, as well as prudential requirements. Next slide, please. Okay, what about regulating new cryptocurrency activities? So we talked about increasing the scope of regulation for existing regulated cryptocurrency activities. This is the regulation of entirely new cryptocurrency activities. And basically, they can be split into a couple of categories. Provision of custody services in relation to cryptocurrencies. So that will be regulated, but how it will be regulated remains to be seen, and that will be proposed on, I imagine, in the next couple of months. Where you provide the service of transmitting cryptocurrencies, that's also going to be regulated in the near future, and again with the details to be proposed on. cryptocurrency brokerage services. So this would be similar to a securities brokerage services. It's just that instead of security tokens or capital market products, you simply provide the brokerage services in relation to cryptocurrencies. And if that's the case, then you will be regulated in the near future. Next slide, please. I mentioned this greater focus on non-cryptocurrency digital assets. So essentially, I think that there is a move towards looking at security tokens simply because, at least from the perspective of the Singapore regulators, cryptocurrencies are not suitable for retail investors. And a lot of the proposals that I've mentioned are geared towards protecting retail investors. Whereas security tokens, by virtue of them being essentially tokenized versions of capital market products, they are well understood, or at least better understood by the population in Singapore. And I think the Singapore regulators see that there are deep benefits to be had for progressing these security tokens. So I'll give you some examples of what has been done. The MAS actually introduced the Sandbox Express, and that deals with people who want to become a recognized market operator, including those that want to allow trading of security tokens. So basically security token exchanges. With the Sandbox Express, it's basically a safe space where these applicants can introduce their product and service and do so with a shorter period of time before graduating and actually getting the full license, which is what InvestaX has. Other innovations that MAS would be looking at would be things like stable coins that are essentially backed by bank liabilities. So I think there's a large interest in that right now amongst a number of banks in Singapore, and certainly that's something that we're looking at also. Next slide, please. So I'm done. Nishta, back to you.
Yep, thanks, Adrian. That was a quick overview of the Singapore framework as well. I think I see a very active chat group here going on. So our team members and panelists have tried to answer some of the questions, but we'll still take a few. And this is the first one that maybe, Adrian, I'll pose it to you. There's a question which says that, is crypto lending and staking regulated in Singapore?
Who is this from? Is this from a law firm?
It's from us actually. I would say it is from InvestaX. We've always tried to find an answer to that.
But I think you've got to split crypto lending and versus crypto staking. With crypto lending, that's not regulated. And actually, don't take my word for it. Go and read the two consultation papers that I discussed that were released in December. There's a specific statement in the consultation paper that says crypto borrowing and lending is not regulated. So there you go, number one.
Okay.
Should it be regulated? Well, I think the activity in itself, again, is not regulated, that's clear. But there are proposals to limit, if you're already a licensed entity, there are proposals to stop you from lending customer assets, lending cryptocurrencies. So it's not that the outcome to this, let's say the proposal is adopted, right? The outcome to this is this. If you incorporate a company and it doesn't do any other crypto activities, and you simply borrow and lend cryptocurrencies, that's not regulated. You don't need a license. But if you are an existing license holder under the Payment Services Act, if the proposal comes into effect, you cannot borrow and lend cryptocurrencies. That's the way I think it's being addressed. Now, the second question on staking is quite an interesting one, and I struggle with it a little bit. Now, I would encourage you to go and read up on what's happening with, I think it's Kraken. The US SEC is actually, if I remember correctly, investigating the staking services that Kraken is providing. So, when it comes to staking, we've got to be quite nuanced about it. So right off the bat, I'll say this. Again, if you go and look at the two consultation papers that came out in December, MAS has said that in general, they don't actually regulate staking. But I think the position is a little bit more nuanced than that. Because if you're talking about staking as in like Bitcoin or Ether, and you just stake and proof of stake or one of those functions, and you get you get tokens back, that's probably not regulated. But what about if you, let's say if I set up a company and I tell all of you, I will help you stake as a service. So you are no longer staking it by yourself. I will help you stake as a service. Then it becomes a little bit more nuanced, right? What happens if I say, well, Nishta, Joy, Megan, give me your tokens, and I'm quite skillful, so I will choose when and where and with whom to stake these tokens with. And I promise you that I'm skillful, so I will try my very best to generate a return based on my ability and when, where, and with whom I choose to stake with. I will take all your tokens and I'll pool them together, and I will exercise my skill and discretion. I will try to generate a return for you, and you will get a return based on how many tokens you're given to me for this staking service. What does that sound like to you? It becomes more and more like some kind of fund management endeavor, right? That's one aspect of it. I could also provide you with a service where I don't say anything about my skill and discretion. I simply say, hey, you know what? I know it's administratively inconvenient for you to stake, so I will just make it easy for you administratively. My fee is a fixed fee. What your return is the same as if you would stake it yourself. I don't exercise any discretion. I simply provide administrative service. If that's the case, I think it's less likely that this service is a regulated one. Or just a last example, it could be that I tell you, Nishta, you know what? Provide me with your tokens. I will help you stake it, but I'll put it in a wallet and I'll keep the tokens for you. And as and when you want to get them back, just tell me and I'll give it back to you. Or you want me to send it to someone else, I'll send it to someone else for you. But in the meantime, as long as they're with me and you don't give me any instructions, I will stake it. What does that sound like to you? It sounds like you're providing a wallet that holds tokens, right? And the default is like, if no instructions are given, then you stake it. So again, that to me sounds like something that could be regulated. So it's quite nuanced, I think, and especially if you provide staking as a service.
Yep, I think it would depend upon the structures, as you mentioned. If it's a service and you need to drill down deeper to understand if discretion is being used or is just administrative. Yeah, good to learn that, actually. I think we have a few more questions. I'll call Hagen for this one. So there's always questions around reverse solicitation of securities when it comes to EU. Are there any strict rules in EU that, if firms in Singapore have to sell or market their products there, how do companies go about doing that?
Yeah, thanks, Nishta. So the EU is interesting in that it has an overarching framework in the form of MiFID, the Markets in Financial Instruments Directive, and various other instruments relating to the securities markets, for example, relating to central securities depositories, reporting of derivatives, etc. So it always depends on the type of product that you're concerned with. But here, if we're concerned with securities, it's more likely to be MiFID. Now, under MiFID, national competent authorities are given some discretion to determine exactly how they structure the scope of the territorial scope of their national member state level regulatory frameworks. So I think reverse solicitation is one of those areas where there is some leeway for national competent authorities to take a view. For example, BaFin in Germany or the FCA in the UK, would have the ability to determine to what extent firms in places like Singapore and elsewhere outside the EU can accept customers based in Germany, based in the UK, based in France, wherever, without those firms, being drawn into the local regulatory framework. For that reason, it kind of depends on the member state in question. I don't think there is an overarching answer for the EU as a whole. Certainly for the UK, I can say that we have this so-called overseas persons exclusion, which I mentioned earlier very briefly. It's slightly up in the air as to whether the overseas persons exclusion will apply under the new crypto assets framework that is being introduced in the UK. But at the moment, it does allow for some degree of reverse solicitation. So for that exclusion to apply, say if you're a Singapore securities broker, you can basically service a UK investor wholly on a cross-border basis without any physical presence, without the use of any physical presence in the UK, provided that you comply with the financial promotions framework in the UK. So that means either you operate within an exemption that allows you to market to sophisticated professional or high net worth investors, as they're called in the UK, or you don't market at all and you essentially receive inquiries from UK persons on a reverse solicitation basis. So that would be the position at the moment, prior to the new framework being switched on for crypto assets. So security tokens would just qualify as legacy securities under the existing securities laws in the UK. And reverse solicitation would be possible, would be permissible. But going forward, there's a question mark as to that. And similarly, we'll have to see, with MiCA being introduced, the new markets in crypto assets regulation being introduced across the EU, to what degree reverse solicitation will still remain permissible across different member states.
Yes, thanks, Argan. I think that's quite clear that it's a little bit of territorial play when it comes to EU, and each regulator has its own boundaries in terms of reverse solicitation. Okay, I think just one last question, and this has been a very interesting discussion, and I saw that there were some of the questions on that on the chat as well. It's about DAOs, and I think I'll pose this to Megan. Megan, which jurisdictions are coming up with regulations in DAOs, and do you see that DAOs are going to be regulated everywhere, and there would be a requirement for a legal wrapper around a DAO? Is Megan still with us? Sorry. Oh, I think I don't see her. Or maybe if anybody from the panel wants to chime in on that. If not, then I think we are good. We'll wrap it here.
I can maybe just comment very briefly on legal wrappers for DAOs, because it's something that comes up very frequently in our practice. So I think Megan alluded to this in relation to one of the actions that was taken by one of the US regulators. The regulator found that the DAO in question, because it was an unincorporated association, it was just a collection of individuals who were using an online platform, purely, an on-chain platform, without the use of any legal wrapper, that gave rise to basically this sort of unlimited partnership between those individuals, and all of the participants were jointly liable and subject to unlimited liability as well. So I think in connection with any establishment of a DAO, that's certainly something to bear in mind. You want to limit the liability for participants, and you also want to make it very clear where the DAO's liabilities are incurred, both for contractual purposes and regulatory purposes. So it does make sense to use a legal entity of some sort for that reason. And we do recommend it, even though it's slightly antithetical to the ethos in the DeFi space, of course, because it's all about operating outside the institutional confines and basically using completely decentralized structures. But I think the art is really to combine some form of decentralization with the use of a legal wrapper. And I won't go into the details on that. We could do a whole separate webinar on that. But it is possible, typically through the use of, for example, offshore entities like Cayman Foundations that support DAOs and that operate pretty much on a decentralized or semi-decentralized basis, and then the centralized operations are onshore. And typically, you can also achieve proper delimitation of legal liabilities that way.
Perfect. Thanks, Arvind. That's helpful to note that Cayman Foundation is one of the more suitable, structures to put across a DAO. Okay, I think we are slightly above the time, and thank you everyone for your patience. Thank you to the panelists. This was a great discussion today, and everyone else who joined us. We are looking to have many other classes as a part of our masterclass series. I know that there were some people in the attendees who wanted to know about Thailand, as well as Korea, Australia, which are each coming up with their own regulations and guidances. And so we will kind of host another one very soon. So please watch out the space for that. Once again, thank you and have a lovely weekend here. Thank you, everyone.